Next topic is Mines and Mineral Development Amendment Bill 2021. ठीक है. This was why this is in news because Lok Sabha and Rajya Sabha both have passed this bill, and this bill seeks to amend Minerals and Mine Development and Regulation Act 1957. ठीक है. So this act deals with a lot of changes that are in consonance with the National Mineral Policy of 2019. It seeks to replace Minerals and Mines Development and Regulation Act 1957. मतलब it is not only amendment, it also seeks to replace the existing bill. Okay. So what are existing laws for regulation of development of mines and minerals in India? The first one is MMDR Act 1957. The second one is Coal Mines Special Provisions Act 2015. ठीक है. And National Mineral Policy 2019. तो हम सबसे पहले देखेंगे National Mineral Policy. What is the foundational policy underlying the underlying policy which governs the development of minerals and mines in India? Okay. The very important thing is the first and the very important thing about mines and minerals is कि India produces around 88 minerals. ठीक है. 88 minerals. The second one is minerals are what? Minerals are property of people. Property of people. ठीक है. Because they belong to everyone. Okay. The second very important thing is minerals are property of people. If they're property of people, how is government trying to regulate the use of minerals? ठीक है. So why are people not going to the coal mines and digging all the coal out? Because the government acts as trustee. The government acts as trustee of the minerals. What? The government acts as trustee of the minerals of the whole country because all the minerals are vested to the government of India and it holds those minerals in the trust of people of India. ठीक है. So government acts as trustee of the minerals. Okay. Sorry. What is National Mineral Policy? The first one is grant of industry status. In 2019, the mineral policy stated that the mining sector should be granted industry status. Fine. Although industry status is not defined in any law. Industry status has not been defined under any statutory law or constitutional law or any kind of law in India. But what are the benefits of providing industry status to a sector or an industry or a business or a mining or a sector? ठीक है. The first one is कि when a sector is defined to be an industry, ठीक है, तो हर स्टेट के जो इंडस्ट्रियल लॉज हैं, इंडस्ट्रियल रेगुलेशंस हैं रिगार्डिंग क्रेडिट, है ना, रिगार्डिंग द लेबर एंड रिगार्डिंग द बेनिफिट ऑफ द इंडस्ट्री, ठीक है. नाउ दोज बेनिफिट्स विल बी अकॉर्डेड टू द sector that has been granted the industry status. Okay, what are the benefits? The first one is the benefits that are already being accorded to industries, है ना. अगर माइनिंग को इंडस्ट्रियल सेक्टर डिक्लेयर कर दिया, फॉर एग्जांपल मणिपुर डिक्लेयर्ड स्पोर्ट्स एज इंडस्ट्रियल सेक्टर वेरी रिसेंटली, तो अब हर स्टेट अपनी इंडस्ट्रीज को प्रमोट करने के लिए बहुत सारी पॉलिसीज बनाता है, ठीक है, एंड बहुत सारे टैक्स में बेनिफिट्स प्रोवाइड करता है, बहुत सारे रूल्स और स्कीम्स लेके आता है हर स्टेट, ठीक है. बट व्हेन a particular sector is granted the status of an industry, so that particular sector becomes the beneficiary of all the welfare schemes for that all the schemes that are being run for the that particular industry in that particular state, ठीक है. Although industry status as a status is not being defined under any Indian law. Second one is encourage dedicated mineral corridors, ठीक है. For example, अगर सिंहभूम is a region where iron ore and coal are basically extracted. छोटा नागपुर प्लेटू, है ना. अब ये मिनरल डेंस एरियाज हैं, ओके. अब यहाँ से इवैक्यूएशन ऑफ मिनरल्स टू द प्रोसेसिंग सेंटर्स इज वेरी इंपॉर्टेंट, ओके. So to develop all these dedicated mineral corridors, like Dedicated Freight Corridor Corporation of India Limited is developing what? Dedicated freight lines, ठीक है. Freight line means ऐसी ट्रेन लाइंस जहाँ पे माल ढुलाई के लिए डेडिकेटेड ट्रेन चलेंगी, ठीक है. तो सिमिलरली ऑन द सिमिलर लाइन डेडिकेटेड मिनरल कॉरिडोर्स फॉर द एक्सट्रैक्शन एंड ट्रांसपोर्टेशन ऑफ मिनरल्स फ्रॉम द माइंस टू द प्रोसेसिंग सेंटर्स. ओके. Harmonize the tax levies and royalty with the international standards. Currently India में taxes on mineral and mining is around 10 to 14%. ठीक है. India is one of the highest taxed country in respect of minerals and mines. The international standard is about 4 to 6%. Okay. This shows that the companies or the international corporations are not ready to bring their technology to make efficient mining or scientific mining more efficient in India because of the high taxation that they face in India. Okay. So it says that the underlying policy should be so that it harmonizes the taxes, levies and royalty. Okay. With the international standards. The fourth one is rationalize the reserve areas. Many areas have been priorly reserved for what? Public sector units only. Okay. Now rationalize those areas to open up for private sector also, so that the private sector can bring its own technology, you know, because public sector mining is fine, but there has been a consistent lack of growth. जो एक CAGR कहते हैं इसको, compounded annual growth rate, CAGR. मतलब annual growth rate of the mining sector has been stagnant over time. ठीक है. Because most of the mining was concentrated in the hands of public sector units. Okay. Due to which the technological advancements did not take place in the mining sector, and hence, despite the fact that India produces 88 minerals and the capacity of India is similar to Africa and Australia, but still we are importing coal from Australia and other minerals from other countries. So to improve our mining capabilities, to improve our self-dependence or Atmanirbharta in the sector of mining, what we need to do is we need to rationalize the sector so that it can be opened for privatization also. Rationalization का मतलब privatization नहीं है. Rationalization का मतलब है कि जो list है, जो reserve list है, उस reserve list में बहुत सारी चीजों को हटाया जाए और उनको open up किया जाए privatization के लिए. That is called rationalization. It is a precursor to privatization, of course. Now, what is the status of mineral ownership in India? The first one is state and the second one is union. Now, Constitution says that all the mineral within the boundary of a state is the owner of that mineral. Okay, that means the royalty that is going to accrue from the mining of that mineral is going to accrue to the state. Whereas all the mineral that is under the sea or is under the exclusive economic zone or under the continental shelf or under the open sea, open ocean, ठीक है, like polymetallic nodules, ठीक है, तो वो सारे मिनरल्स का जो माइनिंग अथॉरिटी है एंड जो माइनिंग के थ्रू रॉयल्टी आएगा वो किसको जाएगा? यूनियन गवर्नमेंट को. ओके. द सेकंड थिंग इज entry 27 of state list. It says that right to regulation of mining activities and mineral development is within the state boundary, lies with the state government, subject to the condition of the entry 54 of the central list. Okay. 7th schedule में there are 3 lists. Okay. The first one is state list, the second one is union list, the third one is concurrent list. तो state list में ये कहा है कि within the first one is कि all the mineral that is within the boundary of the state is owned by the state. The second one is कि although it is being owned by the state, but the rules, the right of making regulation and rules for the development of mining in that area or mining of that mineral within the state boundary lies with the state, subject to the conditions which are provided under the entry 54 of the union list. Now, what is the union list entry 54? It says that right to regulation of mines and minerals throughout the country lie with the state, except for those minerals for which the parliament decides it to be in the national interest. ठीक है. That means अगर कोई मिनरल पूरे इंडिया में कहीं है, फॉर एग्जांपल यूरेनियम, and parliament has declared that uranium is of the mining of uranium of national importance, then uranium cannot be mined by the state government. That is, the state government cannot grant concessions or license for the mining of uranium. Why? Because the parliamentary law has declared it to be the mineral of national importance. Okay. Now in pursuance of entry 54, okay, in pursuance of entry 54, the central government enacted what? Minerals and Mine Development and Regulation Act 1957. In the pursuance of entry 54. Now we are going to deal with that act. MMDR Act 1957. The mines were divided into two parts. The mines were, this act has, first I will tell you beforehand, the act has 4 schedules. Okay. The 4 schedules. We'll be talking about the 4 schedules right now. The mines were divided into two parts. The first one is captive mines and non-captive mines. Captive mines were declared to be those mines that were to be held for some specific end use. ये mines कैसी होती थी? To be held for some end use, some specific end use. End use का meaning क्या होता है? For example, if a power sector, if there is a company which generates powers, ठीक है, and it uses coal, it's a thermal power corporation for example, then it can access coal from some mine जहाँ पे वो mining भी कर रहा है और इस mining से ही coal अपने power plant में भी employ कर रहा है, ठीक है. तो if that corporation is using this mine, then it cannot sell the mined product into the open market. It can only use that product for its own purpose. Okay, मतलब simple है. For example, this is NTPC. NTPC is National Thermal Power Corporation. It uses coal for production of power. So for example, it is mining coal from some specific mine, ठीक है? In, for example, in Jharia, है ना? Now it cannot sell the coal that has been mined from this mine to the open market. It cannot sell. It cannot sell the coal that has been mined from that Jharia mine because NTPC has taken this mine from the government on the specific license that it will be using the specific mine only for the purpose of its own coal power generation. Okay. It is called captive mine. All other mines are called non-captive mines. मतलब ऐसी mines जहाँ से आप normally extract करके mineral ore को open market में auction करते हो या बेचते हो जो भी. तो for the there was in Minerals and Mine MMDR Act 1957, there was a classification of mines into two parts. The first one was captive mines, the second one was non-captive mines. Now, second very important point is the states had power to issue mining license, because the states are the owners of the minerals within their state boundaries. Okay, and the whole territory of the India is divided into either union territories or the states. So union territories, of course, the union government is having the power, but in the states, the power to grant license or the power to grant permit for mining was with the state governments, subject to those minerals which were placed in the Schedule 1. Okay. Subject to those minerals which were reserved for center. Center, yeah. As I told, this act has 4 schedules. This act has 4 schedules and some minerals were mentioned in the first schedule. First schedule में पहले कौन-कौन से mineral mentioned थे? The first one is coal and lignite. Okay. Or second, atomic minerals. Atomic minerals. Now coal and lignite, that means for the permission or the license for mining coal and lignite cannot be granted by state governments. Okay, because that has been reserved for the central government. The second one are atomic minerals. That means atomic minerals, for example, lithium, beryllium, these are all uranium, plutonium, monazite, sand. These are all atomic minerals. That means the permission for mining of these minerals whether they lie in the state or offshore, cannot be granted by the states, because they were mentioned in the first schedule of this act, and the first schedule contained those minerals that were reserved for central government and not the state government. The central government also had the power to declare any mining activities as captive mining. That means if one needed to apply for mining of some mining from some for some captive purpose, for example power generation, they do not have to apply to the state government. Instead, they have to apply to the central government. Okay, but very important thing is, okay, although the mining of these was the permission for mining of these minerals were granted by central government, the royalty went to the state governments as well, because of the basic nature of the fact that the state government was the owner of what, the minerals within their territories. Okay. Now, fourth very important thing is, the central government had the power to declare non-minor minerals. There is no such term as major minerals. Okay? Major minerals is not defined under any section of MMDR Act. But section 3E, okay, section 3E, sorry, states that the central government is having the power of declaring any any mineral as minor mineral. Okay, but non-minor mineral का declaration जैसा कुछ नहीं था. तो any mineral that has not been declared a minor mineral is non-minor mineral or major mineral. ठीक है? That is section 3E of MMDR Act 1957. अब minor minerals, there are 55 minor minerals. ठीक है? तो minor minerals के रिगार्डिंग जितना भी पॉलिसी डिसीजन है, जितना भी रॉयल्टी का डिसीजन है, जितना भी माइनिंग का डिसीजन है, वो सारा स्टेट गवर्नमेंट्स के पास है, खाली माइनर मिनरल्स के रिस्पेक्ट में. ओके. अब माइनर मिनरल्स में एग्जांपल्स अगर हम देखें तो द फर्स्ट वन इज फॉर एग्जांपल चॉक, लाइमस्टोन. ओके. द थर्ड वन इज clay and sand and boulder. ठीक है. तो ये है कुछ माइनर मिनरल्स. इनके रिगार्डिंग जितना भी पॉलिसी डिसीजन, डेवलपमेंट ऑफ फॉर वेदर द माइनिंग और द डेवलपमेंट ऑफ द मिनरल lies with the state government, and that is the exclusive power of state government. Fine. Now this act also stated that, now this is the Amendment Act. Fine. But there is another act regarding the mining in India, that is Coal CMSB Act 2015. Coal Mining Special Provisions Act 2015. Coal Mining Special Provisions Act 2015. This act, what this act did was, it did two things for coal mining. Okay. Coal mining has been mentioned in Schedule 1 of what, MMDR Act 1957. That means all the policy decisions and all the decisions regarding the development and the mining of coal are made by central government, okay, and not by state government. So now central government, in the pursuance of that schedule, has made this Coal Mining Special Provisions Act 2015. It was basically an amendment act into the Coal Mines Act, the earlier one. ठीक है. यहाँ पे क्या हुआ? The coal mining was open to private sector. First one. Mining was open to private sector. This was the first thing. The second thing was, coal mining was open to all. Coal mining was open to all. Open to all का meaning क्या है? Earlier what the process was, कि coal mining was reserved for the industries that are engaged in steel, power, coal mining itself, and iron ore extraction. मतलब the coal mining was reserved for the industries that were already engaged in iron ore extraction, steel production, power production, and coal mining extraction itself. मतलब only 4 kind of industries were having the power of for applying for the what, coal mining. That too was reserved for private public sector, like Coal India. Coal India is a Maharatna company, and it has had the monopoly over mining of the coal in India. Now what the basic changes that CMSB Coal Mining Special Provisions Act 2015 did was, the first was, it opened it for private sector. That means the private companies can now also apply for coal mining licenses. The second was it was open to all. That is, you need not to belong to the four categories of steel mining, iron ore extraction, power production और iron coal mining itself. ठीक है, मतलब अब किसी के पास coal mining का experience ना भी हो, that person can also apply. Okay, so these were the changes made in Coal Mining Special Provisions Act 2015. ठीक है, but now MMDR Act 2021 has been brought. This is a very progressive law in the sense that it tries to remove the bureaucratic hurdles. It tries to open up the mining sector for a wider section of people by trying to attract private infrastructure, private investment in the mining sector. Okay, so the first one is removal of end use, the restriction of end use of minerals. That means the captive mines का जो process था, that has been ended now. That means the mines that were in earlier laws, central government had the power to reserve certain kind of mining activity as for captive mines. Now that captive mine, the concept of captive mine was based on the end use of the mineral. जैसे we took the example of NTPC. NTPC is using some mine from Jharia and they are mining coal and using for their own purpose, but they are not able to sell that coal they are mining into the open market. Okay, now that end use restriction has been ended. That is, we are not going to have any kind of restriction as to how you are going to use your product after you mine. Okay, you can either use it for yourself or you can sell it in the open market. Now the second very important provision is sale of mineral by captive mine. जो existing captive mines है, if they are able to fulfill, okay, if they are if the captive mines that are existing, if they are able to fulfill their own demands, then after fulfilling of their own demand for the mineral, they can sell up to 50% of their mining into the open market. Okay, now the captive mines have been allowed to sell up to 50% into the open market after fulfilling their own need. But earlier, what was the provision that the royalty was not granted to the government? Okay, now royalty to the government will have to be paid. Okay. Third point is auction by the central government in certain cases. This is a very contentious provision in the sense that the central government can now prescribe a time limit for the completion of the auction. In consultation with the state government, a term has been added. That is why I have put it in the brackets. That is, the central government may prescribe to the state government that, for example, you have to auction some mineral within 3 months. If the central government prescribes that, of course, in the consultation with the state government. If the state government fails to auction the mineral that has been extracted from some mine within 3 months, then what will happen? The central government will auction that mineral itself, but the royalty that is being paid will go to the state government itself. That is, now the central government will be able to auction some mineral that was being earlier auctioned by state government, but the royalty will go to the state government itself, जैसा कि पहले था. Okay, if the auction is not completed within the stipulated frame, the central government can auction by itself. Okay. Now, very important thing is a national mineral index will be developed. Now, what is this national mineral index? National coal index was developed. National coal index was developed in 2018. Okay. Now, what is national coal index? National coal index is nothing but an index to track the price. For example, the sale of the coal in the open market is going to take place via ठीक है. National coal index is an index that tracks the price of the coal that is being sold. Okay, depending upon the weights that have been assigned, I'll tell you how. For example, auction, notification या notified price, and what this is import price. Fine. Now what government has did is to make the process of selling the coal in a transparent fashion, ठीक है, and for a better price discovery mechanism, a national coal index was developed. This coal index is the accumulation of all these three kind of prices that are being obtained for the sale of coal, ठीक है. For example, auction मान लो 100 rupees kg हो रहा है, for example. Notified price is 78 rupees, for example 80 rupees kg, and import price is 120 rupees kg for coal. Now what government did is auction price पे 70% weight, okay, notified price पे 20% weight, and import price पे 10% weight. 10, 20, 70, that amounts to 100. This is one thing I'm telling you for example. This is only for demonstration. This is not in reality. अब क्या होगा? 70% of 100, okay, that is 70. 20% of 80, okay, 16, and 10% of 120, that is 12. This will be the index for coal. Now this will be the actual price. Now the person who is going to buy coal from all the people, है ना, he will be knowing that the national coal index is around 98 rupees. Fine. So he can make a better decision. Okay. Similarly, national mineral index is being also developed based upon the auction, notified, and import price of the minerals. Okay. That is national mineral index. Now this is a very contentious issue from the environment point of view. The transfer of statutory clearances will take place. इसको हम समझने की कोशिश करते हैं. What is this? What happened? What earlier was कि transfer of statutory clearances. What the earlier in MMDR 1957 and 2021. Okay, what are the changes? For example, if the mining license of a company expires, in that case MMDR stipulated that the statutory clearances that the older company had were to be transferred to the newer company, the company which has now got the license for mining, for a stipulated period of 2 years. ठीक है. For example, A was the original company that was mining. ठीक है. अब इसका लाइसेंस एक्सपायर हो गया. नाउ बी अप्लाइड फॉर द लाइसेंस ऑफ माइनिंग एंड बी गॉट द लाइसेंस फॉर माइनिंग फ्रॉम माइनिंग मिनिस्ट्री ऑफ माइंस. बट अब इस कंपनी को भी इस कंपनी के जो स्टैट्यूटरी क्लियरेंसेस थे सारे ट्रांसफर हो जाएंगे फॉर 2 years. ओके. And now this company will have to obtain the statutory clearances on its own within the stipulated period of 2 years. अगर ये कंपनी फेल हो जाती है to obtain this statutory clearances within 2 years, then its license for mining will be cancelled. ठीक है. अब ये statutory clearances होते क्या हैं? Statutory clearances, okay. The first one is environmental clearance. Environmental clearance. Environmental clearance, Ministry of Environment, Forest and Climate Change provide करता है. For this, a Parivesh portal has also been launched. Parivesh portal. This is also important from current affairs point of view. ठीक है. A Parivesh portal has been launched. Parivesh portal is a single window clearance portal to apply for all kind of environmental clearances that a mining or a company may need. ठीक है. The second one is from Pollution Control Board. Okay. The third one is, मतलब इतने जितने भी क्लियरेंसेस हैं ये ऑब्टेन करने होते हैं हर कंपनी को बिफोर सेटिंग अप एन इंडस्ट्री. ठीक है. सिमिलरली इट वर वैलिड फॉर माइंस ऑल्सो. अब क्या है कि ये सारे स्टैट्यूटरी क्लियरेंसेस जो एक कंपनी ने ऑब्टेन किए थे पहले, नाउ दे विल बी ट्रांसफर टू earlier what under 1957 Act also they will be transferred to B, but only for a period of 2 years. Now this 2-year term has been removed, and simply the clearances that A obtained for itself will be transferred to the clearances to B, and there is no 2-year period. That means it does not have to obtain new clearances for the mining at the very same place. Okay, understood. So transfer of statutory clearances. Okay, now allocation of mines with expired license. If the new lease auction has, if the when an auction, what happens is, when a company, for example, the example we took recently was, for example, if a company का इस कंपनी का लाइसेंस एक्सपायर हो जाता है, ठीक है, तो स्टेट गवर्नमेंट कैन यूज दैट, and for example, if the mining license of company A has expired and the state government is not able to auction that mine to some other company, then what state government can do? State government can transfer the license to some public sector unit instead of some private entity. ठीक है, तो what state government can do? The state government can transfer that license for mining to some public sector unit. Okay, and then, but what is the expiry of license? Expiry of license को हम define कैसे करेंगे? The first one is either इसका जो stipulated period of time था वो expire हो जाए. For example, if A obtained a mining license for 5 years and 5 years have transpired, मतलब 5 साल खत्म हो गए, तो इसका license expire हो गया. Otherwise, if A obtained a mining license for 5 years but it was not able to start the mining operation within 2 years, so that also is considered the expiration of mining license. Okay, तो यहाँ पे कुछ नहीं, वही defined है ना. The state government can transfer the mining lease to a public sector unit, but up to 10 years. ठीक है. And the sixth one is non-exclusive reconnaissance permit. Non-exclusive reconnaissance permit, reconnaissance मतलब to make a assessment, है ना. For example, if you are going to some forest and make some geographical assessment of the forest as to what kind of minerals may be present there, that is called reconnaissance. Okay, so non-exclusive reconnaissance permit, that is, not one area or one block cannot be allotted to one company alone. That is the policy. Understood? मतलब one block or one area of minerals can be allotted to multiple agencies. That is, non-exclusive reconnaissance permit can be granted. So that was the Mines and Mineral Development Regulation Act 2021. Okay.